Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss legal victories and challenges to your fundamental freedom and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, founder and chairman of Liberty Counsel, explains the latest legal issues all across this country. In the courtrooms of America, Liberty Counsel is winning the battle for your constitutional freedom.
The Supreme Court decides two specific cases on marriage, the Federal Defense of Marriage Act and Proposition 8. I'm Matt Staver, founder and chairman of Liberty Counsel. Joining me to talk about this is Matt Barber, vice president of Liberty Counsel Action. Matt, we've talked a little bit about this particular situation that the Supreme Court came down, both 5-4 decisions. On the one hand, the Federal Defense of Marriage Act saying that the definition of marriage is unconstitutional, and I use that in quotes because it's not in the Constitution that they grounded this decision. And the other one, that the Proposition 8 case, they lack standing, and so therefore they set aside the Federal Court of Appeals ruling, leaving standing the lower court decision. There's significant implications that we need to unpack for both of these. But I think here's what Scalia said, and I want to start off with this on the Federal Defense of Marriage Act case. Scalia, in his dissent, said this. He said that in explaining the court's jurisdiction in the DOMA case, and in its decision to strike it down, he says that quote, springs from the same diseased root, an exalted conception of the role of this institution in America. The diseased root is that this court thinks it's so exalted that it can get away with doing anything, and it can cut the line, the tether that connects it to the Constitution.
Well, if the Constitution is whatever of 5 justices on the United States Supreme Court, based on the changing whims of the day, decide that they think it is, and not actually says it is when you get to the letter of the law, well, then the Constitution is nothing at all. If it's a living, breathing document,
it's just the opinion of 5 people.
Well, that's chaos, and what we see here is judicial chaos, and the end result of that poisonous root is judicial chaos, and this decision will create chaos.
Yeah, this decision will create chaos. You know, let's look at even some of the technical things of this particular decision. Should the court even have decided this case in the Federal Defense of Marriage Act? In the Federal Defense of Marriage Act, what you have is you've got the plaintiffs who in 2007 decided to go get married in Ontario, Canada. They lived in New York. Well, in 2007, New York didn't recognize same-sex marriage. So one of them dies in 2009. In 2009, New York did not recognize same-sex marriage. So now they file for some tax returns and some other benefits, and they don't get them because the Federal Defense of Marriage Act says it's only one man and one woman. Well, now the court says, well, they have standing. Well, first of all, if in 2009, when the actual case, so-called injury would have began, they were not in a state that recognized same-sex marriage. It doesn't matter whether Canada did. They didn't recognize same-sex marriage, and they didn't recognize Canada's same-sex marriage. So they had no right to ask the federal government to recognize something that their state does not recognize. That's number one. Number two, getting beyond that, once it got filed in court, and the lower court ultimately found that the Section 3 of the Federal Defense of Marriage Act was unconstitutional, that's what the plaintiffs were claiming. That's what the court agreed with. And guess what? The United States Department of Justice under Eric Holder, they said, you know what? We're going to accept that decision too. We agree with it. So you got the plaintiffs and the defense and the court all agreeing. So how does it get appealed when they're all on the same page, when there's no adversarial situation?
Right.
It's the first time in the court's history that the court has decided the case without two parties disagreeing.
No controversy.
There's no controversy.
Yeah, and it's what's amazing is that it's so inconsistent when you look at what the court did with the Prop 8 case. They punted there. They said that plaintiffs had no standing, or rather, those defending Prop 8 had no standing. Yet, I guess because a majority of the court decided that it wanted to get to the merits of Section 3 of DOMA, they somehow divined that there is standing. The inconsistency is palpable. It's mind-boggling.
Yeah, you got federal DOMA plaintiffs filing suit, Federal Department of Justice defending court rules it's unconstitutional. You got California Proposition 8, plaintiffs file suit, state attorney general defending the federal district court ruling it's unconstitutional. In both cases, the attorneys general for the United States and the state all say, we agree with that decision. So now what happens is, how does it get all the way up to the Supreme Court, the Prop 8? Well, the people who were interveners, the people who supported the initiative, they appeal it up to the Court of Appeals and then to the United States Supreme Court. The Supreme Court says, no. You don't have standing. When the plaintiffs and the state attorney general agreed with the lower court, the case is over. You can't bring it up any further. No more case or controversy. We're dismissing you. Now it goes back to the trial court decision. That's the only thing that stands. But over here now, no, you do have standing. We want to reach the merits, and therefore we do reach the merits. You have two conflicting decisions. It's absolutely conflicting. And when you see courts doing this, arbitrary decisions, they no longer follow rules. They no longer follow the Constitution. It's just whatever five of them can come up with.
And you stole my thunder a little bit. That's exactly what I was going to say. That what we see at play here are two things that the court, a Supreme Court, rails against anytime any lower court presumes to engage these things. And they are arbitrary decisions and capricious decisions. So this was arbitrary and capricious on the part of the United States Supreme Court to inconsistently do what it wants to do on a whim. But that's in keeping with this living, breathing model of constitutional interpretation, where basically the judges say, we're the ultimate arbiters of what is constitutional and what is right and wrong. But they've now taken it to the next level by saying that something that when the Constitution was framed, central to, of course, gay marriage, same-sex marriage, is homosexual behavior. That's the underpinning. That's what defines same-sex marriage. When the Constitution was framed on all the law books, nearly without question across the country, the continents across the country, it was called a crime or a crime against nature.
Yeah, crime against nature.
How could it possibly be now suddenly be a constitutional right to something that has always been considered a crime against nature?
And when you think of, the Declaration of Independence speaks of the laws of nature and of nature's God. Well, what is that? That's natural law. That's something that is created as part of the universe. It's part of the natural created order. We know some of those laws as the laws of physics. Gravity is part of the natural created order. You may disagree with it. You may not like the fact that when you jump off a cliff, you're going to fall and hurt yourself and get killed. You may detest that law, but you can't do anything to change it. Other laws of nature are inherent as well. There are certain moral laws that are laws of nature, and that's why they called it a crime against nature. Right. It's a crime against nature because it is contrary to the laws of nature or natural law. Marriage has always been part of the natural law. It is not something that courts or civil institutions have had the authority to redefine. It would be hubris, and it would be unbelievable for people to think they have the power and the authority to do so.
It's a level of hubris no less than if the court just suddenly, Justice Kennedy decided with four other liberal justices that we were going to reverse, that the Earth's rotation effective tomorrow will reverse, and that the Earth's gravitational pull will lessen by 50%, and so be it ordered. And they ordered, well, of course it's not going to happen. But it took the same kind of arrogance and hubris to say that they could somehow redefine natural marriage. What is simply, same-sex marriage being something that marriage can never be?
Well, Justice Sandra Day O'Connor, and I want to elaborate on this a little bit more. In 1992, she said that the Supreme Court has only the authority that the people give it. And that's the authority that people believe that the court is acting in a legitimate way. If the court ultimately goes across that line and acts in an illegitimate way, contrary to the Constitution, contrary to history and reason and logic, then the people say, oh, that's just too much. That's just ridiculous. The court loses its authority. The question is will the people ultimately accord this decision as one that's legitimate? I say that it's an illegitimate decision, as illegitimate as Roe versus Wade was illegitimate. In 1973, we just accepted it as so. And so therefore the court had the power to continue to pretend that it could destroy innocent human lives and give other people the opportunity to do so. The question is, what's going to happen with this? I urge you to go to marriagesolidarity.com, and sign on the letter supporting marriage and pledging that you will draw a line in the sand, a line that we cannot and must not cross. We're going to be talking about the implications of this case as we continue on Faith and Freedom in future days. But it is significant in terms of the implications that we will see in the short term. This is a major defining point in American history. It's a decision point for you. Go to marriagesolidarity.com and sign the Marriage Solidarity Statement. Also go to Liberty Counsel's website. Remember Liberty Counsel in your financial support as regular financial supporters. It is because of your support that we're able to continue advancing and defending marriage. You can also order resources from lc.org.
You have been listening to Faith and Freedom with Liberty Counsel. We hope that we have motivated you to stand up for your faith, family, and freedom. We can accomplish a lot when we work together. Get informed and get involved today. Sign up for our free monthly newsletter, The Liberator. We will send it out to you free of charge. Stay informed with our Liberty Alert email updates. Just click on the website at www.lc.org or call us at 1-800-671-1776. Tune in next time to learn more about your rights right here on Faith and Freedom.